Welcome to the June 2015 edition of the Roundup. We've put on a number of webinars this month, but we've chosen 4 to show to you today.
Check out the description below the video if you want to skip ahead to a particular webinar you're interested in, and if you want to watch the full video you can do so by clicking on the hyperlink or just go to our website lexiswebinars.co.uk.
Our commercial property webinar this month focused on the issues of nuisance following the recent case of Coventry and Lawrence. Our speakers for this one were Paul Darling QC and Robert McCracken QC. Both speakers are recognised experts in the field, and Robert was counsel for one of the parties in the case. So they focused on the issues of amenity notices as well as the different emphases of the multiple judgments.
We're in the realm of common law amenity nuisance. The Supreme Court judgment, which was delivered last summer, included individual contributions from all the justices who sat. They all had different emphases, although some common themes emerged, which we'll try and identify during the session. I think it's fair to say that the judgments will provide many happy hours for academics and plenty of scope for advocates in future disputes. But I think there are some themes that we can identify for day-to-day practice.
Early in the month we were joined by Gavin Smith, Tim Parker and Maria Scotland to talk about financial remedy cases. They went through the 3 different stages of an application, which are the first appointment, FDR and final remedy, and they provided tips on how best to plan and manage financial remedy cases. So Matt, we've heard a lot in the news lately about tax evasion and tax avoidance, and you chose a webinar on the issue?
Yeah, that's right. So I've chosen a Tolly tax webinar which focused on inquiries and investigations into tax evasion and avoidance. So the speakers for this were Ian Marston and Tessa Lorimer, and they focused on tax evasion and avoidance against a rapidly changing environment.
Do you know why the revenue withdrew that sort of third option of cooperating with them but not admitting tax fraud? Because it sort of struck me at the time that don't they want people to come forward and settle? And I mean, was it pressure from Margaret Hodge that they were doing too many deals with people and not prosecuting enough people? Or
I don't know if that's the case. I think it's part of the overall tightening up of all the disclosure facilities that are offered by HMRC. As we've already said, the LDF is closing early in December of this year, as are the Crown disclosure facilities. The contractual disclosure facility, where they're alleging fraud, again is something that HMRC are tightening up on, because all this information is coming online as a result of the common reporting standard, and they feel that they
don't need it anymore.
They don't need it anymore.
So Melissa, the last webinar you've picked is one on IP infringement.
Yeah, we were joined by Philip Westmacott and Gemma Barrett from Bristow's, and they looked at damages or accounts of profits for IP infringement. So they started off by providing a refresher of the topics and then went on to look more specifically at innocent infringers, the IP Enforcement Directive and cross-undertakings for damages.
You were mentioning account of profits, and certainly when I started as a patent litigator, I have to say that accounts were surprisingly unpopular. Almost everybody went for damages because I think they felt, well, that's based on my accounts, I've got control of that, my accountants can look at my accounts and say what damage I've lost. But I have the slight impression that maybe accounts of profits have become a bit more popular.
Yeah, it seems to be, particularly in the designs and the trademarks field rather than, say, patents, it seems to be quite a few more recent cases with accounts of profits. So it's interesting because the tradition is still that it's an unpopular remedy for the reasons that you mentioned, that you don't know really what the defendant's made, and if they get in some very clever accountants, they may hide their profits. And I think there was a feeling of that from the Celanese and the BP case, obviously a very famous patent case, that obviously what the claimant claimed was a lot larger than what they got awarded in the end, and particularly when you're sort of deducting costs and things like that, it's a sort of concern that you're not going to get as much as you might deserve.
That wraps up this month's roundup video. Hopefully you found it helpful. If you don't yet subscribe to LexisNexis webinars, you can do so by going to our website lexiswebinars.co.uk, sending us an email to webinars@lexisnexis.co.uk, or you can follow us on Twitter @LexisUKWebinars.
Thank you for watching.